Welcome to Current Affairs. My name is Nathan Robinson. I'm the editor-in-chief of Current Affairs magazine. I am joined today by Professor Julie Suk. She is Professor of Law at Fordham University School of Law. She is the author of the books We the Women, The Unstoppable Mothers of the Equal Rights Amendment, and most recently, After Misogyny, How the Law Fails Women and What to Do About It. Professor Suk, thank you for joining us on Current Affairs today.
Thanks so much for having me.
I want to start with the concept of misogyny because getting us to a clear concept of misogyny is very important in your book. When people are accused of being racist, they often say things like, I'm not racist, I don't hate anybody. And I think with misogyny, the same thing happens. We say, well, I can't possibly be a misogynist. I don't hate or despise women. And you argue that in some ways it is correct not to think of misogyny as hatred of women. And you try and get us to a more accurate and helpful definition of the term. What you point out is that it's true that misogynists often don't consciously hate women, but that doesn't mean we don't have a society saturated with misogyny. And so let's start with how you think we should conceive of the idea of misogyny.
So I think it might be helpful to think of misogyny as existing, even if there's no misogynist. If you take misogynist in the most conventional, everyday understanding, which is the woman hater, the man who hates women. And there are still such people. There are misogynists. So I'm not saying that doesn't exist, but I'm saying that even if you didn't have a whole lot of misogynists, you could still have a legal structure that we could describe as misogyny, because the hatred and violence and discrimination and hostility towards women is just a manifestation of a larger dynamic that I'm describing, what I call in the book overentitlement and overempowerment. Specifically, that misogyny comes from a very long history of patriarchy in the culture and in the law. And it's a system that's not primarily based on hatred or violence against women, although sometimes it was enforced by violence against women. It's a legal system and a culture in which many things that are in the public interest are extracted from women, or things that are in the common good, women are expected to contribute for free. So it's women's pain and forbearance and sacrifice that help society survive and flourish. But all of those contributions are just expected and undervalued, undercompensated. And I think the primary example of this has been the way that the law has regulated reproduction, including right now, the many abortion bans that we've seen go into effect since the Supreme Court's decision last year in Dobbs versus Jackson Women's Health.
Right. I'd like to just read a little passage from your book from page 85. This is under the subheading Redefining Misogyny. You say, in the modern liberal political economy and legal order, some men, often by virtue of wealth or leadership positions in the economy or in politics, possess tremendous power over those who depend on them for their livelihood or future advancement. The law may authorize all persons, including powerful men, to hire or fire whom they please and to engage in consensual sexual relations. Even in the absence of physical violence, empowered men can abuse these rights through aggressive sexual conduct towards persons who are subject to their power. When men wield their power to maximize their gain without due regard for the vulnerable person on the other side of the transaction, they abuse their rights. They corrupt social relations and the economic and political institutions with which the law entrusts them. Understanding misogyny as overentitlement and overempowerment captures this important insight that lies beneath 21st century demands for gender justice. So you're talking about how even if there's formal legal equality, we can have, these massive power differentials in society.
And absolutely. I think that's primarily what the Me Too movement was about. The Me Too movement was not just about sex or unwanted sex. It was about the fact that men in positions of power felt entitled so as to make consent kind of irrelevant. So through things like non-disclosure agreements, and of course, I think the recent indictment of Donald Trump in New York and the way that the hush money was in fact a form of corruption, which may or may not have criminal consequences. But the overall structure is that people who are overempowered with wealth or political power then have this sense of entitlement to women's pain and sacrifice. So then in a system in which we just declare everyone equal, that power dynamic becomes invisible, when in fact it's that power dynamic that makes significant anyone's violence or hatred against women. But I think one of the most important insights of the Me Too movement was that this was not really, or even primarily, about sex or sexual relations. It was really about power and abuses of power.
Mm-hmm. When we start to think about and we start to notice the operations of power in society, then what looks in terms of the formal progress of equality under law like a great deal of strides towards women's equality, right? You go through the whole history of patriarchal laws, and various women's activist movements over the course of centuries have successfully managed to get formal equality under law. But when we start thinking about these concepts that you talk about, entitlement and power, the picture looks a bit different.
Absolutely. And I think one pernicious dynamic in the United States in particular is that formal equality under the law, which was such an important achievement for legal feminism, has now come to undermine other mechanisms that might actually empower women. And I think you see that contrast, the positive side of the book, what to do about misogyny. I look at something that has become a predominant trend and very important to feminists outside the United States, which is the adoption of gender parity rules with regard to positions of power. So rules that say when you're running for elected office, the political party must have equal numbers of women and men, or corporate boards, you need to have no more than 60% one gender on that corporate board. Those are the kinds of rules that formal equality has a real problem with. They say that's actually sex discrimination if you're going to single out a particular gender and say that they get an advantage in a process by which you choose corporate directors, for example. So I think that's a really important tension, that the thing that we often hold up as the achievement of formal equality comes to stand in the way of the empowerment and building of real infrastructures that would dismantle patriarchy and replace it with something more democratic and just, that all of those actions become questioned and challenged under a regime of formal equality. And that's true not only for gender, but of course, we're seeing it right now with regard to race, that increasingly you have challenges to affirmative action. And those challenges to affirmative action as a legal matter are being presented as non-discrimination. You can't help disadvantage racial minorities because that's race discrimination. And that's a really important problem that I think we're still struggling with in US law, but there are many different ways in which that problem's been resolved in other constitutional democracies that I think it's important for us to look at.
Mm-hmm. It can sound paradoxical to people at first to say, well, the pursuit of equality under law can undermine equality. But I think this idea that you bring in of, well, let's think about power. Let's think beyond the letter of the law. Let's think about who feels entitled to do what. Let's look at who is in control of decision making. And then you see that if the law is not capable of changing the fact that all of the power, or a hugely disproportionate share of the power, is held by men, right, who still dominate Congress and corporate boards and every, any sort of powerful position, the presidency, obviously, then the law isn't fixing the massive inequality between men and women.
Great. When I talk about the law enforcing these dynamics or being inadequate, particularly formal equality being inadequate to really dismantle patriarchy and transition us towards a more inclusive democracy, when I talk about that, I'm also specifically thinking about the limits of courts. There's a lot of law. There's lawmaking, policy making, but then there's courts. And I think the strategy in the United States with regard to anti-discrimination as a principle of constitutional law, we use the equality norm to attack, say, Social Security policies that distinguish between men and women. And often what that means is that things get dismantled without replacing them with policies that would actually change gender roles within the family or lead to a greater participation by women in the political and economic sphere.
One of the things that I think is so important about what your book does is that, I think we can make these critiques, and I have heard these critiques of, formal equality, this idea that, purely preventing discrimination isn't going to fix the power problem. But what you do is you bring in some concepts that help us think more clearly about what we are trying to get rid of, if it's not just, unfair, rules that are explicitly different, to treat people differently on the basis of sex. What are we trying to get rid of? I mean, you use ideas like, you bring in the concept of unjust enrichment, and you say that, this legal concept can help us understand what the problem is here.
Yeah. So if you think about patriarchy as being a system in which only men have legal rights and women are dependent. So even just the vote, men are expected to exercise the franchise on behalf of their dependents, the wife and children. Property rights. Married women don't have property rights because only men do. And these are all the things that are really important to first wave feminism. And it's believed that getting the right to vote is important, but only the beginning to dismantling all these other structures by which, and of course, the solution appears to be women should have equal rights under the law, equal property rights, and equal rights to political participation. But if one of the central problems, that the logic of patriarchy, the reason women don't have rights is not because women are hated, but because it's expected that women have a certain role with regard to childbearing and child rearing, which would be somehow incompatible with the exercise of those rights. That expectation of women's role of childbearing and child rearing doesn't change even after women are given equal rights with regard to the vote, and even with regard to just understanding women as welcome in some respects, at least not discriminated against within the workplace as a matter of law. And so I think part of the problem is that the cultural expectation that women do all of the childbearing and child rearing, but then that's kind of not really considered a major activity of the state to support that childbearing and child rearing. And this gets us back to the problem of abortion. We tend to think, and I think it's because we're conditioned by the Supreme Court's landmark decision in Roe v. Wade to think that the reason people have a right or should have a right to abortion, if they should, is that having a child is a totally private matter. And therefore, the government should leave you alone to make your own choices about whether to have a child and how you're going to raise that child and so forth. And I think in many other constitutional democracies, there's a public recognition that having a child has enormous public consequences, and including benefits to the society and the state. And that's why the state has an interest in unborn life and in children. And what that means is that if you're actually going to transition from patriarchy to an inclusive democracy, it may be important that you give women a choice, but it may also be equally important that you support caregiving. In many countries, including Germany, paid parental leave is considered a constitutional requirement because of this dynamic by which you understand that what it means for women to be equal is totally equal participants in both the life of the home and in public life. So that's one example where if you're really going to deal with the unjust enrichment problem, then there might actually be certain positive duties by the state to support childbearing and child rearing instead of it tacitly expecting women to do it for free without much choice.
Let me see if I understand this correctly. So what you're saying is that under this framework, it's not just that paid parental leave is a good, fair public policy. It's that if you don't provide women, when they have children, with paid maternity leave, you are in some ways taking something, almost violating their rights. The society is being enriched by their contribution, but not compensating it. And so we should almost think of this in the same way we think of infringements upon property rights or speech rights or other rights. It's not just, it would be nice if we did this. It's that to not do this is a violation of basic rights.
Yes. So one framework that I introduce in the book and in other writings that I've contributed to more specialized journals is that we've got the abortion framework all wrong in thinking that the reason you should have a right to abortion is privacy. I say that the proper frame is taking of property for public use. So that is something we have a doctrine in constitutional law under the Fifth Amendment, and it's an explicit clause that says that the government can't take your property, your private property, for public use without just compensation. And that's been extended to mean that sometimes the government passes some regulations that end up severely reducing your property value or make your property unusable, right? Then under some circumstances like that, you might be entitled to compensation from the government. And I think that's the way that we should think even about an abortion ban, that women are being forced to contribute, but their contributions are then not valued. So the government then does nothing, for example, about the very embarrassingly high rates of maternal mortality that we have in the United States, which disproportionately affect Black women, right? So you force women to be pregnant, but you don't address maternal mortality. But also, very importantly, we've had a very long struggle in this country for something that's quite basic in many other countries, which is a legal requirement that pregnant workers be treated fairly and accommodated when their health requires it. That's been a long struggle. About half the states passed laws on that in like the last 10 or 15 years. The Congress finally passed the Pregnant Worker Fairness Act in December of 2022 after a lot of resistance. But this is also something where if you're forced to be pregnant or expected to bear a child, but there's high rates of maternal mortality, there's no law that allows you to keep your job in health and safe conditions. And so this work of creating a born child out of an unborn life, it's kind of expected, but totally not supported by the state. And that's what I'm talking about when I say that this is the overentitlement of society to women's sacrifices. And that is actually the dynamic of patriarchy, which under patriarchy and even after is sometimes enforced by violence. That is the expectation that women have sex, whether they consent to it or not. The expectation that they give birth and raise children, whether they really want to or not. That all of these things are what keep the patriarchal legal system going. Under patriarchy, it's enforced by violence. It's enforced by legal rules that deprive women of property and voting rights. But even when it's not enforced by those things, we also have other mechanisms, even in modern societies, by which that unjust enrichment is left alone. And I argue that that too is a legal order of misogyny, even if the primary problem in that legal order is not the violence of specific misogynists.
Mm-hmm. Yeah, so a lot of talk in the discourse about we need to, is America going to have enough babies being born, or is there going to be a labor shortage, and not much talk about what the rights of those expected to perform the unpaid work of giving. I mean, if you assume that society needs people, which we do, and that having people, who do the work and keep everything running is a benefit, and then you start to think, well, that's the work of creating the people for society. I mean, what I like is you sort of reconceptualizing everything in a way that is very helpful because, as you say, we have this tendency to think of it as a private decision, or it's almost like a selfish decision. It's for you. And so we don't think of things like maternal mortality, dying in childbirth as like a failure to protect, when in some ways it is also kind of we should think of it as like an imposition. Like, are we failing to protect someone from this natural thing, or are we imposing it in someone and thereby violating their basic right?
Yeah. So one important analogy, and this doesn't come from me, I think that many observers for a long time, and certainly early advocates of feminism in the early part of the 20th century, often made the analogy between military conscription and motherhood, because these are gender differentiated ways in which you could say that men are expected, and often they don't have a choice. I mean, the whole idea behind the draft is that in times of need, that's something that the state can extract. I think we should have a debate about that too. But I think it's long been assumed what makes the state is that it can draft men and expect them to die for the state. That's the extreme version of it. But I think very often there's been an analogy to motherhood. That's something that's expected. But of course, as long as the draft has existed, it's been compensated. And we have people come back from war, or even if they haven't served it in war as such, we have departments of Veterans Affairs. We have a whole system of support. We have veterans preferences in certain job categories. So the idea is that fundamentally, we're just talking about a democratic state and what would it actually mean, not just to have formal equality, but to really think of everybody as an equal citizen and equal participant in terms of what the state can expect from them and how the state compensates or values their contributions.
Now, I have to ask you to respond to what would be the immediate libertarian objection to the analogy, which is that in the case of the draft, you receive a notice in the mail saying you have to go. But in the case of pregnancy, you do not receive a notice in the mail saying you're expected to bear a child for the good of the nation, and that there is a choice. I take it you feel like the operations of social power mean there's less of a choice than we like to think there is, but perhaps you could explain more why you think the analogy is valid, even if there isn't the same degree of outright state coercion.
So let me make sure I understand. I think depending on the legal order that you live in, that there may or may not be a choice with regard to conscription, and there may or may not be a choice with regard to motherhood. So I would say in all of the states right now in the United States that have instituted near total abortion bans, that's basically conscription into motherhood, especially when you have abortion bans that don't have exceptions for rape. That's basically forced motherhood.
Right. Certainly, yeah.
And one approach you could take is that's just under any understanding of morality. That's just wrong, right? But I'm willing to entertain the possibility that if we have a theory of the state in which we accept that the state can conscript men into military service. And of course, many people will say that's just wrong, right there. Mm-hmm. But even if you were to operate under the set of assumptions where you say that the state can conscript men into military service, and that's the worldview from which you're reasoning about abortion bans, I would say at the very least, if the state thinks that it can conscript women into motherhood, there are some basic requirements so that motherhood doesn't become slavery. And those requirements should be analogous to what men get for being conscripted, which is a paid maternity leave, safe conditions. I mean, it's a little different with conscription because, if you're being sent to war, how safe is it going to be? But certainly the idea is that veterans are then taken care of. And I just think that we don't think of the enrichment of society by motherhood, whether it's forced or not forced. We don't think of that enrichment as being unjust at all. And I think that's the frame that I'm trying to shift by rethinking what misogyny is, by thinking about misogyny as not just an isolated hateful act, but as a holdover from a legal system of patriarchy and everything it assumes and expects based on gender roles.
Mm-hmm. You relay some of the history of changes in law over time, and I really want to touch on one of the more fascinating chapters of your book, which certainly upended my entire understanding of history, is your chapter on Prohibition, because you point out that there's this conventional understanding of Prohibition as this almost this silly disaster, right? There was this sort of collective delusion that we should ban alcohol, and then, a few years later, America realized what a terrible mistake it had, and why would we put an alcohol ban in the Constitution, and then they repealed the ban. And you tell this fascinating, total alternative story that perhaps you could relate to.
And I don't want to take total credit for it because a lot of historians have worked on it as well. But it is true that I think that the dominant narrative is the one that you've described, but there's a very rich historical literature that looks at Prohibition as a long movement that runs parallel and often intersects with first wave feminism in the late 19th century. Some of the feminists or the suffragists that we celebrate, like Susan B. Anthony, Elizabeth Cady Stanton, were equally involved, or at least they saw suffrage and temperance as being tied together. I see it as just kind of another approach to some of the social problems that women experienced on the ground because of patriarchy. So the idea that men had control over all of the family's property, including their own wages as well as any wages that the mother or children brought in. And what that meant is that if they were spending it all on alcohol, that would be a disaster for the economic well-being of the woman. And of course, there's a domestic violence narrative as well, that alcohol was contributing to domestic violence and unrest. And so because of this, on the one hand, in like the mid 19th century, temperance means focus on men, try to persuade them not to drink anymore and not to beat their wives and so forth. But the movement starts turning towards institutions by saying, oh, let's not focus only on the men who are getting drunk, telling them to sober up. They say, let's focus on the alcohol industry and the male space of the saloon. Let's try to tell them not to serve alcohol to our husbands, or let's try to get them to shut down in our town. And it's only when women start organizing in the temperance movement against these businesses that the businesses start asserting property rights to get the women off their properties, women who are protesting and trying to make things better for themselves. And it's in response to corporations asserting their business and property rights that you get the women's temperance movement saying, actually, we need a constitutional amendment that prohibits the sale and manufacture of alcohol. Interestingly, the amendment did not address actual drinking or even making alcohol at home. It was about the industry. It was about shutting down an industry that they thought was unjustly being enriched at their expense because they were getting all the family wages. Men were getting drunk and then acting in ways that had severe consequences for the physical and economic well-being of women. And of course, they turned to a constitutional amendment, not like right out the gate, but the constitutional amendment proposal grows out of other efforts to use law to improve their situation, which failed. Like for a while, they were trying to sue the saloons. If their husbands got too drunk to actually work and support them, they would blame the saloons and try to sue them. Those lawsuits had some limited success, but not really. When there's a lot of failures of law that the Women's Christian Temperance Union starts arguing, and the women lawyers who are newly minted, because, women were excluded from the legal profession for much of the 19th century, but towards the end of the 19th century, you have women lawyers who really start thinking about a major reset to the entitlements and power in society. And they sort of see prohibition as that major reset. And when I tell a positive story about that, don't worry, I'm not trying to say we should have prohibition part 2 where we take away alcohol. But I do think that the insight there is that people understand that it's not focusing on men or even specific small legal reforms that's the answer to this problem. It's really, you need to reset the entitlements. You need to go after the institutions that are benefiting from the dynamics that make their lives so miserable.
I had kind of understood that there was overlap between, the suffrage and temperance movements, and that there were a lot of women active in that. But I think you did that kind of caused me to rethink the whole prohibition movement was, pointing out what you're saying there, that, the whole kind of argument is being made by women for prohibition is that the job of the law is not just to, guarantee equality, not just to give the vote, but to address these ways in which women are being harmed by these overentitlement, overempowerment that you discuss in the book. And that when the law doesn't step in to redress the harms that come from disproportionate power of men, the law is effectively enforcing those power differences.
Yeah. So I wouldn't say it's not that the failure to act becomes misogynist action, although I think that sometimes that's true. I'm also suggesting as a historical matter that we see that there's a failure to act. I don't think the failure to act is the same thing as active harm, but I think you can trace the ways in which anti-discrimination law. So we make positions available to women, but we don't necessarily address the power dynamics in institutions that are dominated by men. So it doesn't actually translate into equal participation. So I think we can trace the ways in which that goes. And I'm not saying it's necessarily the case that failure to act always enforces something pernicious, but you could trace the way that one thing develops from another. And with prohibition in particular, there are all these small steps where they think they have a legal gain, like the ability to sue saloons. But then once saloons start saying, oh, we have property rights, so you're not allowed to protest on our property anymore, that's when they say, well, maybe the saloons should not have a constitutional entitlement based on property to be in our neighborhood. And that, that's where they get this notion that maybe there should be a resetting of entitlements in the Constitution with regard to the manufacture and sale of alcohol.
And that resetting of entitlements is almost like to say that the women's rights not to be abused by alcoholic husbands are more important than saloons' property rights. And that should be codified in law.
Right. I think that is what they were trying to say and do. And I don't think that move always has to take this form. It's always difficult for us to really take it seriously because it was about alcohol. But another good example, which I think is similar, is in Sweden in the 1960s, there was a debate about patriarchy, about gender roles in the family. And of course, feminists tended to emphasize how the expectation that women do all the childbearing and child rearing. And it's an expectation that is sometimes enforced by law. It's enforced by law if you don't give women a choice with regard to childbearing, let's say like by banning abortion, or it's also expected by law if you exclude women from any roles in society other than motherhood. So if you exclude women from certain jobs or professions, right? So that's how patriarchy enforces that. And we tend to emphasize that harms women by excluding them from important opportunities to flourish as a human being. Well, in Sweden, they started saying in the 1960s, oh, it's also harmful to men because men are also confined. Like they're excluded from certain forms of human flourishing if they're expected not to spend a lot of time doing caregiving and having a meaningful caregiving relationship with their own children. But what's so interesting in Sweden is that instead of fixing that problem by just saying no discrimination on the basis of gender, that's one move. They did not focus on the non-discrimination bit of it. They focused on policy making. They're like, let's have childcare centers and let's fund them. Let's have paid parental leave for both mothers and fathers and let's fund that, right? And we're still struggling with that. There's an executive order just like yesterday where Biden greatly expanded access to childcare, particularly in the federal civil service and in areas over which the president has power. But there's a great dysfunction right now in American politics by which we know that Congress in its current state is highly unlikely to do anything really meaningful to create access to childcare on the federal level. There was a moment in the 70s when a bipartisan Congress was doing that. But because of a political dysfunction that makes that impossible, we have some limited moving the needle now coming from the executive branch. And this is why I think it's so important not just to focus on equality, but also on the political institutions that are able to make policy to make equality real. And in Sweden, they were able to build childcare centers and fund parental leave for both mothers and fathers, in part because the major constitutional reform that they get in Sweden in the 1960s is not gender equality, civil rights. They got a unicameral legislature that was able to implement a lot of social democratic policies. And it's not just, it overrepresented one group of people. I mean, there were a lot of electoral reforms to try to make that cameral legislature more representative. And these are the kinds of things I feel like, we get really upset about the fact that the courts are no longer protecting a constitutional right to abortion. And we forget about the fact that in a normal, democratically functioning Congress should theoretically be able to fix that by passing the Women's Health Protection Act.
Well, yes, because public politics is just people don't want, abortion criminalized. So if we had a democracy, it shouldn't be too much of a problem because...
And I think the problem is sometimes we assume that we do have a democracy and people don't want the Women's Health Protection Act. But that's not true. On the federal level, I mean, we have a democracy that overrepresents the people of Wyoming as compared, severely overrepresents the people of Wyoming as compared to the people of California. If you look at the design of the Senate, 2 senators for every state. The Women's Health Protection Act was filibustered twice in the last Congress in the Senate. And now I think we're facing a lot of problems with regard to the entrenchment of power in gerrymandering. So I think eventually there will be questions about how representative the more representative branch on the federal level, the House. And this is why a lot of things that you would think are sensible that most American people would support, including some modest protections for abortion rights, or even very importantly right now, the controversy about the abortion pill. A lot of attention is being paid to a law that was passed in 1873 called the Comstock Act, which anything that causes an abortion, that's criminally prosecutable on the federal level. It was passed by Congress at a time when patriarchy and misogyny, as I define it, were just the norm everywhere, and women didn't have the vote at the time that law was passed. That law is now being brought back to limit abortion in potentially even in states that allow it. This is why I think that if we're really going to get past misogyny, the conversation has to move beyond specific policy issues or even formal legal equality and into what are the structures by which we make law and power gets exercised.
Well, yes, and another thing I like about your book is that the first half of your subtitle is How the Law Fails Women, but the second half is what to do about it. And in many ways, it is a very constructive book. And perhaps as we close here, one of the things you do throughout, you talked about Sweden just there, is that you look beyond the United States. The United States is a very dysfunctional country, as we've indicated here, but also it's a country where oftentimes we're unaware that there are things that other places in the world have addressed or made progress on that we haven't, and that are therefore fixable problems. So are there any other particularly striking examples of things that in other countries they have done that you think we should be looking to as a model as we think about how to move past misogyny in our own legal system?
So I think no model is perfect, in that even in the models that we might say is relatively more successful than the United States, there are still problems. I just want to sort of give a couple grains of salt to that effect. And also, no model is perfectly transferable because the United States is so different. It's much larger. The forms of diversity that we have along various lines may be different from other countries. But I do think that it is a trend in many other countries around the world that constitutional amendments have been deployed to address the problem that we started talking about earlier, which is the tension between formal legal equality and measures that actually empower women or empower disadvantaged groups. I think we're kind of still struggling with that. And I think in many other countries, when the court said, oh, you can't do affirmative action because that's against our idea of formal equality, there were mobilizations in France, there were mobilizations in Germany, there were mobilizations in Italy that led to constitutional amendments that made it really clear that the law could authorize gender quotas in order to reach fairer representation of women in politics, for example, or fairer representation of women on corporate boards and economic leadership. And, in my earlier book about the Equal Rights Amendment, the consistent struggle, which is ongoing for the Equal Rights Amendment, just shows how hard it is to amend the US Constitution. We have an amendment rule that's known to be one of the most impossible in the world. And so I think, on the one hand, the positive models suggest maybe we should be amending the Constitution instead of depending on the courts to give us our rights. But at the same time, there's this larger project of really thinking about why has the US Constitution, one of the oldest constitutions in the world, why has it been so difficult to amend? And how should we think about getting out of the cage that our amendment rule puts us in?
I did just want to ask you, actually, because I take the opportunity of having an expert on the Equal Rights Amendment here, because this is something I have always wondered about, which is how significant do you think the Equal Rights Amendment would have been or would be? Was it and is it mostly symbolic, or do you think that it would actually be a massive, substantive, important change that would affect women's lives for the better?
So that's a very big question. I think at the time that it was introduced 100 years ago in 1923, it could have enacted a massive change, but it wasn't adopted in 1923. It was finally adopted in 1972. And I think had the states ratified it, we would have gotten significant changes. We got some of those changes anyway, because even though we came 3 states short of ratifying the ERA, many states, after they ratified it, were like, you know what, let's get rid of some sex discriminatory laws. That sounds like a good idea. So they did it even without the ERA forcing them to do it. But this is where I think that the ERA has already had tremendous effects even without becoming law. ERA as politics has really changed the way people think about what the Constitution should do about gender. And that's why people now talk about how the ERA is not really necessary because we have a de facto, because all of the organizing for the ERA changed hearts and minds about what they wanted gender relations to look like. We no longer formally need the law of the ERA to get a lot of the benefits of the ERA. But honestly, Nathan, I kind of think this is another unjust enrichment dynamic where women have changed the Constitution, but they aren't founding mothers because there's no text in the Constitution that we give them credit for. To the extent that we buy the narrative that the Constitution already protects gender equality, it didn't come out of nowhere. It wasn't there in 1787. It came out of women organizing, but they're not given the status of constitutional authorship because we haven't been able to complete the process by which the ERA is officially added to the Constitution. And so do I think that if we got it now, it would radically change the state of affairs? No, because we also live in a world where we expect constitutional rights to be interpreted and enforced by the Supreme Court. And after what I saw from the Supreme Court's interpretation of the 14th Amendment, I don't have high hopes that the current sitting Supreme Court is going to take the ERA and start protecting a lot of women's rights in the most progressive direction. But that said, the ERA is a text that was written in 1923 and adopted by Congress in 1972 and completed ratification arguably in 2020. And I think that's definitely an improvement over the Supreme Court's tendency to think that the only interpretation of the 14th Amendment that's really valid was the one that, the accepted meaning at the time of ratification, 1868. So I think definitely having text that was written and ratified in the 20th and 21st century is probably going to be a better ground for women's rights than anything else we have in the Constitution.
Well, the book is After Misogyny, How the Law Fails Women and What to Do About It by Professor Julie Suk, available from the University of California Press. Professor Suk, thank you so much for joining us on Current Affairs today.
Thank you so much. It was great talking with you.
The Current Affairs Podcast is a product of Current Affairs Magazine. If you are not subscribed to Current Affairs Magazine, visit currentaffairs.org/subscribe today and get our glorious print edition. The Current Affairs Podcast is released regularly every week on patreon.com/currentaffairs. Thanks for listening.